Kouri Richins was arrested in 2023 and accused of the 2022 murder of her husband. Yes, it took a while for them to arrest her. Yesterday, we went over the 26 new charges against her, which are in the mortgage fraud, forgery, money laundering realm, but they are interwoven in time with the charged attempted murder and murder of her husband, Eric Richins. Eric Richins, before the attempted murder and murder, had discovered, based on allegations from the prosecution, that Kouri Richins had taken out an unauthorized home equity line of credit on his home that they were living in. This was a home purchased prior to marriage that, per the premarital agreement, was separate property, but she had taken out a loan on it and used that $250,000 loan to start her real estate business without his permission. When he found out about that, the prosecution alleges in 2020, he started meeting with a divorce lawyer and setting up a trust to protect his assets and his children, and took Kouri Richins off as beneficiary. So they were still married, but he removed her as beneficiary on his life insurance policy and made sure that his business, he ran a company with a business partner, a stonemasonry company that was, by all accounts, doing very well. That was put into the trust so she wouldn't get a part of it. The home was in the trust, even though it was separate property. In the premarital agreement, it was put in the trust. And his sister, Kouri Richins, because Richins is Kouri's married name, was put in charge of the trust. After the murder of Eric Richins, Kouri Richins discovered that she was not the beneficiary of the largest life insurance policy, that the home wasn't going to her, and she was not entitled to half of the business. In the premarital agreement, we saw this yesterday, and we've seen this in other documents in the case, it indicated that she would get Eric's half of the business if he predeceased her while, and that's a legal term, but if he passed away while she was still alive and they were still married. This is an area of law that is deeply specific. These cases are all being handled by the same judge that is handling the criminal case, which is unusual for me. A lot of criminal judges in my jurisdiction, California, that are handling criminal matters. If you brought a civil lawsuit dealing with probate to a criminal judge, they would look at you like you were suggesting the unimaginable. They would just blink at you and go, what? But in a number of jurisdictions we have traveled to, criminal judges also handle civil accounts. But the world of family law, estates, all of it is very specific. If you go to most lawyers and say, hey, I would like to talk to you about family law, they will go, no, that is not what I do. It is the one area of law where lawyers don't try to might could it. They know enough to know they don't know. We are dealing with Kouri Richins, criminal defendant, in one of these cases, plaintiff, and Kouri Richins, Eric Richins' sister, Kouri's sister-in-law, who is the executor of the estates. We're going to take a look first at the estate versus Kouri Richins and mother et al. We will shorthand this one as the accounting part. Who distributed assets of the estate? Do those assets need to come back to the estate? Hey, that's not your money. That money goes back to the estate. So the accounting part is the first one. Who gets what is where Kouri is suing. That's the second one. Let's get into the accounting and where the estate thinks that some of that money went. This is Kouri Richins Benson, personal representative of the estate of Eric Richins and trustee of the Eric Richins Living Trust. So Katie is not in this litigation individually, they're not suing Katie as a person. She's the representative for these two things. Versus Kouri Richins, Lisa Darden. Darden is her maiden name. Ronald Darden, and Richins Reality. Life insurance fraud. Eric and his business partner, pursuant to the terms of a separate buy-sell agreement, purchased life insurance policies on each other's lives. Completely standard. I think any partnership attorney would say, if you are going to be in a partnership and your partner is working in the business, physically working in the business, life insurance on the other person, that pays out to the business is not just a good idea, but almost invaluable. Upon information and belief prior to Eric's death, Kouri illegally logged into Eric's account with New York Life, accessed the $2 million policy that Eric had purchased for Kouri, and tried to change the beneficiary designation from Eric to herself. Between 2014 and 2022, Kouri obtained several policies of insurance on Eric's life. In total, these policies provided over $1.5 million of coverage in the event of Eric's death. Don't do this without talking to someone. It's fucking creepy. After Eric's death, Kouri filed death claims on each of those policies. Upon information and belief, Kouri received over $1.5 million in insurance proceeds as a result of Eric's death. If the life insurance companies aren't going to sue her to get back the $1.5 million, it should go into the estate to repay the estate for the money she took from the estate. This is more tea than is in the criminal lawsuits. I didn't know she got funds. She got funds? Well, where the fuck did it go? First cause of action, conversion, stolen bank account money. Conversion means taking something that's not yours, converting it to yours improperly. Second cause of action, conversion, credit card charges. Third cause of action, conversion, tax payments. These are against Kouri and her business. Fourth cause of action, conversion, the retirement accounts, Kouri and the business. Fifth cause of action, conversion, other estate property, Kouri and the business. Sixth cause of action, fraud against Kouri specifically. Seventh cause of action, quasi-contract, unjust enrichment, and or quantum meruit and constructive trust against Kouri and KRR. Other causes of action for fraudulent acts against the $2 million that the estate says they're entitled to. Eighth cause of action, breach of fiduciary duty, saying Kouri was acting as a fiduciary to Eric and her responsibilities, taking care of financial. And so she owed him a heightened duty for that. Ninth cause of action, breach of contract against Kouri. Kouri said she would pay back the $250,000 loan against the house. Remember, the house goes into the estate. So if the value of the home, or if the equity in the home is diminished by $250,000, that's a substantial diminishment of the equity in the house. 10th cause of action, wrongful lien. Put a wrongful lien on Eric's house for the $250,000. 11th cause of action, review of agent's conduct against Kouri with the power of attorney and owed fiduciary responsibilities as the power of attorney. Interesting. 12th cause of action, accounting against Kouri. Show us your books. Where did this all go? 13th cause of action, invasion of privacy, misappropriation of name and likeness against Kouri about the book. 14th cause of action, abuse of personal identity against Kouri regarding the book and the television appearance. 15th cause of action, violations of Utah Pattern of Unlawful Activity Act. We're also seeing the criminal side of this in the new 26 charges. This is in the civil case, which is essentially what property needs to go back to the estate. The other action touches on this as well. Wrongful death against Kouri. So there's the wrongful death cause of action, saying that she caused the death of Eric and therefore caused all of the losses and owes money to the children for the cause of death of their parent. Not just for a parent's future incomes, but the love, companionship, guidance, all the intangible things that a parent should provide. 17th cause of action, personal injury, survival cause of action against Kouri. Battery, this is for the Valentine's Day incident. 18th cause of action, alter ego against Kouri and KRR. They're saying, look, these are one and the same, even though she's calling it a corporation, it's her and it's undercapitalized and we can pierce the corporate veil and just go after Kouri. We don't need to go after the company. The company's not real. 19th cause of action, voidable transfer of the KRR property against the company and the mother who has that house in their possession. Voidable transfer of the KRR property against the company and Lisa, the mother, who they say has the title of that property. 21st cause of action, civil conspiracy, Kouri, mother, brother, with regard to transferring the property. Prayer for relief, money. Give us back all the money. Give us the attorney's fees, all of the money, give it back. Go get it, give it all back. Lawsuit 1 is the estate of Eric Richins and the trust of Eric Richins suing Kouri, her mother, her brother, and her business, saying in some and very simplified, these different monies from tax payments that weren't made, from the lien against the house, from property that was converted, from monies that were taken, from credit card debt that was incurred, from a house that was transferred. All of that is assets and should be assets of the estate, and the estate poured over into the trust. So the estate assets go to the trust. The estate has tax liabilities that they are alleging Kouri Richins caused by not making those payments. So it is in the millions of dollars. And what we learned from that lawsuit that we have not discussed before is that Kouri Richins got paid out some of the life insurance policies she had taken out against Eric Richins and is alleged to have taken out without his knowledge. It is a substantial amount of money, and I can see why the estate is going after Kouri Richins, her business, her mother, and her brother for the money that should be in the estate to go into the trust. The next question is, who are the beneficiaries of the trust, Emily? Kouri Richins' children. Her children with Eric Richins are the beneficiaries of the trust. So all of those monies that they are alleging need to go back into the estate to go into the trust are monies that will benefit the 3 children of Eric Richins as they continue to grow. That's where the money was stolen from, as alleged in this civil action. Some of this will overlap into the criminal action. A lot of it won't. A lot of it, the court has ruled, will stay out of the criminal action. You want to make sure that you avoid piling on things that will make the jury just go, okay, but no, I just hate this person. I can't. Not all of this will come in. Some of the things that will go to motive will come in, but not the full picture of it. Yes, a lot of what is in the estate's lawsuit against Kouri Richins and her family are in the new 26 counts that I previously covered. So we will see it in that case. What happened at the end of this case? Well, it's all stayed pending the criminal cases. So the estate suing Kouri Richins is going to have to wait, which means none of this can get finished and resolved until Kouri Richins' criminal cases are done, in large part, because part of what needs to happen here is Kouri Richins being deposed. And that's not going to happen until the criminal cases are at least in part resolved. They're not going to stay this and wait until all of her appeals have run if she's convicted. They're going to stay this until the end of a criminal trial. And then if she gives a deposition, it's likely that there will be some restrictions on whether or not that could ever be used in future criminal proceedings, should there ever be an appeal that overturned things and more, which might be a reason that we will see Kouri Richins continue to fight her criminal cases, because if she took a plea deal and waived appellate rights, it pretty much shuts the door on the rest of the civil cases, especially when it comes to all of those fraud charges. But if those are all found by a jury, it goes a long way improving the civil cases. And yes, in that estate case, there are causes of action for wrongful death. So it is a very thorough civil action against Kouri Richins, but it's not the only one that is pending, because Kouri Richins sued the estate. Plaintiff Kouri Richins, by and through counsel, complains of and for her causes of action against sister-in-law, not personally, but in her capacity as representative of the estate. Kouri and Eric jointly resided in the family home, including raising their 3 children there at all times from the day they acquired it until March 4th, 2022, when Eric passed away. Since Eric's death and until May 2023, Kouri paid virtually all expenses. This is very parsed language for the lawyers. Kouri made virtually all required mortgage payments. It doesn't convert the asset, though, but it does pose some fairly interesting legal questions. Like, I can see this being a law school question, because her taking over the mortgage payments, does that change the nature of the asset, given that the asset belonged to the trust at that point? And at what point would the trust have taken over mortgage payments and evicted her? Because the trust could have evicted her. It sounds like she lived in the home the entire time from Eric's death in 2022 to her arrest in 2023, though it raises legal interesting questions. In that, it raises also personally difficult questions of, if you are the personal representative of the estate and the executor of the trust, do you want to evict your nieces and nephews, your deceased brother's children? Do you want to evict them from their family home when they are already going through the loss of a parent? It raises really difficult questions. Practically, legally, could Katie have evicted Kouri from the house? Yes. Practically, that becomes a much more difficult issue, right? Kouri made virtually all, I need definitions on that, required mortgage payments, paid nearly all insurance, utility, and other expenses. In addition, prior to Eric's passing, Eric and Kouri engaged a contractor to construct a swimming pool and fencing at the home. That doesn't convert the asset. The work was completed after Eric's death, and Kouri paid the entirety of these improvements from her separate funds. The family home constitutes marital property. The family home has a current approximate value of at least $1.9 million. Kouri is entitled to half of all equity in the family home. Alternatively, if she is not entitled to half of all equity, she is at least entitled to half of the increase in equity value that occurred after her marriage to Eric. The prenup. Eric's marriage to Kouri was his second marriage. Really? How is this relevant other than putting this man's business on the fucking street? Eric's mother delivered to Kouri the prenup agreement and requested Kouri sign it. A true and correct copy is attached. Both she and Eric signed the prenup on their wedding day, with the prenup being notarized simultaneously with their wedding certificate by the very same individual. The assets is limited to business assets and includes only Eric's 50% ownership in CNE, a forklift skidster, scaffolding and saws, 2 trucks, and a dump trailer. Notwithstanding the list of assets showing Eric's separate property, the prenup expressly provides that should Eric pass away prior to Kouri while they're married, the ownership in the business transfers to Kouri. The list of assets does not include the family home, nor does the prenup make mention of real property purportedly owned by Eric. There is a legal argument there then. So this is why we're not in total code red land, because if the list of assets at the prenup doesn't list the home, there is an argument here about if the home becomes marital property and if she's entitled to part of it or 50% of it, which is what she's arguing. Claim for relief, declaratory judgment, the family home. Your Honor, tell us it's mine. Tell us who gets what. Is it equitable division of the assets with 50-50, etc.? Declaratory relief means they are asking the court to decide and declare something. The court can't just make rulings. There has to be a, actionable controversy. That's what declaratory relief is for. Please declare it's mine, or 50% of it is. Second claim for relief, quiet title, family home. Kouri incorporates the allegations above. Kouri's interest and the estate's interest in the family home are equal and identical. They each own an undivided interest as tenants in common. The family home constitutes marital property with equitable division, 50-50. Kouri clearly holds equitable interest in the home and lines out why. So, Your Honor, this home is held by Eric Richins and now by the estate only. I'm asking you to fix the title and say this title is truly held by 50% Kouri, 50% estate as tenants in common. Third claim for relief, declaratory judgment regarding the personal property that goes into the trust. Quiet title to the personal property, same. Kouri's asking the court to say that it needs to be equitably divided, 50% to the estate, 50% to her. Fifth claim for relief, declaratory judgment, the proceeds. Kouri incorporates the above. There presently exists an actual controversy between Kouri and Katie concerning the proceeds. Katie contends or may contend that ownership of the proceeds belong to the estate and that Kouri has no right to it, which is what we're seeing. I mean, they've asserted the arguments that are being made by the estate completely accurately, but they see this very differently. Quiet title to the business interest. Kouri is asking the court to say Eric's business interest does not belong to the estate. It belongs to me. That is what she is asking the court to declare in that declaratory relief. Unjust enrichment. Kouri incorporates the allegations above. Eric's transfer of the family home, the personal property, the business interest conferred a substantial benefit to the estate and a detriment to Kouri. The estate clearly knew of and appreciated the benefits it received. Further, in the event that the estate is the owner of the family home, whether in whole or in part, Kouri has conferred a substantial benefit on the estate by covering nearly all of the costs and expenses associated herewith. So Your Honor, even if some of this belongs to the estate and not me, they owe me money because they've benefited. It would be inequitable and unjust for the estate to keep and retain these assets without compensating Kouri for their value. Therefore, to prevent unjust enrichment, Kouri's saying the estate was enriched unfairly, even if it's their property, that she's entitled to a money judgment against the estate in the amount not less than $300,000, but in excess of $2 million. The estate was enriched and they owe me money. Eighth claim for relief, constructive trust. Eric's transfer of the family home at all constitutes an unjust enrichment. Because it constituted an unjust enrichment and it breaches his fiduciary duty to his wife. She's arguing breach of fiduciary duty and arguing that Eric's transfer of the home, the property, and the business interest to the trust is conversion, and that a constructive trust must be imposed as a remedy. So the court needs to hold it all in trust and divide it up to remedy the conversion. So the estate is arguing that Kouri converted significant assets of Eric, and Kouri is arguing that Eric converted assets that were marital property into the estate, and thereby the estate converted assets. Ninth claim, resulting trust. 10th claim for relief, partition. These are equitable reliefs asking the court to decide essentially who gets what. Remember, I said the first one's more accounting based. It is all of the fraud stuff that's really being alleged. Hey, Kouri did all these things and took money that belonged to the estate. Those things need to go back to the estate. And in this one, Kouri is saying, no, these things actually belong to me. So two separate cases. She's asking for half. So Kouri is asking for an equitable division of the assets. 50% of everything Eric had goes to the estate. Kouri is arguing 50% goes to her. So where are we at looking at both of the civil actions pending regarding the estate of Eric Richins? Well, Kouri Richins is suing the estate saying, hey, not all of that estate property is estate property. Some of it's my property, arguing that the home is not Eric Richins' separate property, but in fact marital property, and she is entitled to 50% of that, arguing that the purpose of the trust was to take care of her and the children. The trust was not attached though, so I haven't looked through it yet, but there is a pending motion for summary judgment. And when we go through that, we are going to see more of this detailed in the arguments from Kouri Richins saying the house is marital property, the trust, once the assets go through the estate into the trust, I am entitled to part of that trust because I'm a beneficiary of it. The business goes to me because Eric and I were married at the time of his death, so that interest goes to me. The will is still in effect. The premarital agreement still in effect. And Kouri Richins is arguing that the premarital agreement, though it separates out all of the business property, it does not separate out the home. And Kouri's argument to that is, one, the home is not accounted for in the premarital agreement. And two, the home was often paid for with commingled marital funds. And three, that she put in a pool. And so the amount that she's improved the property goes back to her. And from the time of Eric's death in March 2022 to the time of her arrest in May 2023, she was paying the mortgage on the home. So arguing that A, that's marital assets, flat out, she's entitled to an equitable division of that marital asset at 50%. And B, even if it is not a marital asset, she has improved the asset by adding a pool, paying for the mortgage, taking care of the asset. And that's unjust enrichment to the estate, the money that she put in. So the estate would owe her back the amount that she improved the property with the pool and the increase in value of the property while she was paying the mortgage. I'm sorry, I can't say paying the mortgage, paying most of the mortgage and most of the other bills, because the lawyers were very clear to say that it was, virtually all. They didn't say all. Where we're going to end up on these cases right now, I think the court will grant this pending stipulation to stay the case until the end of the murder case. I think where everyone's waiting to see is if she is convicted of the murder of Eric Richins, what she is entitled to is going to shift under the law. And so they have reached a point where she needs to be deposed. The estate is arguing that she diminished the assets of the estate through fraud, theft, and conversion. Kouri is arguing that the estate is not entitled to all of these. She's entitled to 50% of the home, the business interest, and more. All of that can shift if she's convicted of murder, because it's going to void some of her entitlements under the law, and it's going to, stop the lawyers from fighting over some of this. But I do think it would be interesting to take a look at that motion for summary judgment. If you want to take a look at it, so let me know in the comments. If you're interested in that motion for summary judgment, in the very nerdy trust and estates arguments, if we take all the rest of this case away from it, the argument of, does this property belong as a marital asset, or does this property belong as an asset to the estate to pour over into the trust? For all of you studying for like the bar exam for wills and trust, I know this is a hypothetical that at the end of the day, you're like, it's all going to get voided if she's convicted. Do we have to answer these questions? But there are some difficult legal questions here to answer about whether or not the home is included in the prenuptial agreement. And we'll need to go back through that prenuptial agreement and the attached schedule of assets again. The arguments about whether it's accounted for or not, if funds were commingled to make that a marital property, even though Eric Richins' name is the only name on the mortgage, etc. Who do the properties belong to? And that, I think, is an interesting legal question that we can continue to endeavor through if you guys want to know. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.